Uh-oh. Oops. I think I got it. Right. I think we've got everybody in now. Okay, good afternoon, everyone, and thank you all for joining us for today's monthly service presentation of evictions and knowing your rights. My name is Nia Murray. I am the programs coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. Also included and presenting with us today on behalf of our partner with Lone Star Legal Aid, we have Mr. Benjamin Daly, who will be providing the information for you today about evictions and your rights. But also included in the partnership, we have the City of Houston's Department of Neighborhoods, the Harris Central Appraisal District, Texas Legal Services Center, Harris County Tax Assessor Collector's Office, Houston Volunteer Lawyers, and the Earl Carl Institute. And together we make up A Month of Service. And basically, just to give you a quick little history, A Month of Service is the collaboration of all of our organizations coming together on a monthly basis and offering a variety of different workshops, resources, and information to the community relative to community empowerment, asset building, asset protection, and the maintaining of generational wealth. We know that there are a lot of underserved communities that are out there. They don't have access to a lot of information as it relates to the laws, their rights, resources, and services. So we decided to collaborate and come together several years ago in an effort to create a larger impact, to reach more people, to consolidate a lot of our existing initiatives and programs, and bring this to you collectively. So we decided to call it A Month of Service. So basically, it's an entire month of all of these different types of workshops. And then the following month, we started all over again. So we used to do these presentations in person at different community centers, churches, multi-service centers, and businesses and things throughout the city. But of course, due to the pandemic, we had to adjust to the virtual platform. But we're slowly trying to get back into hybrid presentations where we will continue to offer them virtually, but also being able to um, uh, have the opportunity for folks that don't have the technical ability or computers and things like that to be able to see the presentations in person as well. So be on the lookout for some of those to come to an area near you soon. But with that being said, this is your opportunity to ask legal expert questions that you may have as it relates to this particular topic on evictions. But do know that the information that does get provided here today is for educational purposes only. It is not to be considered legal advice. We do encourage you, however, to reach out to our legal service partners like Lone Star Legal Aid, the Volunteer Lawyers, and the Earl Carl Institute if you do find yourself in need of any civil legal assistance. And Mr. Daly is going to go over a little bit more detail about some of the other services that are available when you apply for Lone Star Legal Aid. So please do not automatically assume that you will not qualify. It is important that you do actually apply for the service. You'd be very surprised as to what it is that you could qualify for on behalf and actually get legal service or legal assistance that you may need for no charge. So do that. If there's any information that is presented here that you all know of someone that may find the information to be beneficial, we do ask that you pay it forward and share with any family members, co-workers, friends and things of that nature. So that you let them know, hey, you got options here. I sat in on this presentation and I heard this information, and we bring this information to you on a monthly basis. Processes change, laws change, regulations change. So we want to make sure that you have the most current, up-to-date information as it relates to the state of Texas, as opposed to what you would hear from somebody else, someplace else. Or what you would hear on social media. Some people kind of talk in generality about things that don't necessarily apply to Texas law. So it's important that when you receive your information, that you do get the information as it relates to Texas law. So regardless of where you are joining us from, if you're in different parts of the state, know that the information that is presented is relative to Texas law. It's not just for the city of Houston or for Harris County and things of that nature. So if you are joining us on Zoom, please feel free to type your question into the comment section. If you are joining us on our social media platforms, please feel free to type your comments or question into the comment section, and we'll make sure that your question does get addressed. I know that there were one or two questions that were emailed to me in advance, and I'll make sure that those get addressed as well. Do note that we are recording this session, as well as, again, broadcasting live on our social media platforms. So we do ask that you try to keep your questions to be general, and not divulge any personal or detailed information about your specific situation. One, we want to protect your privacy as best we can, and we don't want your information kind of getting out there for everybody to have access to. So do keep that in mind. In addition to that, because it is a public platform, Mr. Daly can only allow or can only give you so much information without getting into too much detail about your own particular situation. So there's some things that he won't be able to address, um, again, in the public setting, and you would need to apply for the services from at Lone Star Legal Aid. So with that being said, thank you all for joining us this afternoon. Hopefully you receive all the information that you came to receive, and you do find it to be beneficial as well. So we're going to go ahead and get into our introduction and move right on into our presentation. So Benjamin Daly with Lone Star Legal Aid, if you would like to go ahead and get started.
Okay, thank you. So my name is Benjamin Daly. I'm an attorney with Lone Star Legal Aid. I am in our Eviction Right to Counsel unit, and this is Eviction Know Your Rights. Before we get started, special acknowledgement to Kim DK, who created this presentation. Lone Star Legal Aid is a 501c3 nonprofit law firm. We handle a wide variety of civil cases in the Houston area, as well as some of the surrounding counties. We represent low-income individuals either in specialized units like mine, where we deal particularly with eviction cases. We also have some general units that cater to special groups such as veterans. So a veterans unit can represent veterans in any variety of civil cases, so long as, it's within our service area. In order to apply, you have to go through application process. We'll give you information on how to do that at the end. You can do it either online or you can call our toll-free number. We can offer anything from simple advice to full representation. So if you come to us with a case and the attorney assigned to it decides that's a case that they want to take to trial, you can get full representation that way. We'll give you more information to apply at the end. So some things we're going to do here today, we're going to talk about leases. We're going to talk about terminating the lease. We're going to talk about what notices to vacate look like. Then we'll walk you through what an eviction process looks like, talk a bit about appeals. We'll touch on some special issues such as public housing and subsidized housing cases. And then we'll talk about some things that might happen if there are conflicts with the landlord, outside of the eviction context. Keep in mind that this is general information. A lot of cases turn on very specific issues or specific facts. So if you are facing an issue and this information isn't specific enough to help, please apply for our services. Additionally, whenever you're in doubt, you can ask for help or ask for advice. As a special sort of note, if we're going to talk a bit about some affirmative cases at the end, if you are looking to sue your landlord, make sure that you talk to an attorney before doing that. And finally, right now, as you probably know, the legislature's in session. There have been some bills filed that deal with landlord-tenant issues. We don't know which, if any of those are going to pass or what that will look like. So just be aware that the information we're giving you is good right now, today. You may want to check back with us in a few months once the legislature wraps up, and we'll be able to go over what sort of changes have been made, if any. So first things first are leases. So the lease is a contractual relationship with you and your landlord. And basically, the landlord is agreeing to give you possession of a piece of property in exchange for some form of consideration, usually rent. Texas allows for both verbal and written leases. If the lease term is longer than a year, the agreement needs to be in writing. If it is in writing, you do have a right to a copy of your lease within 3 days of the lease being signed. If you have not gotten a copy of your lease after that time, there are certain things that you can do, including sending your landlord a demand letter to get it, or in some cases, there's possibly even a cause of action there. Keep in mind that lease terms control in the vast majority of disputes. Leases under Texas law can actually alter the sorts of rights that you have. They can add rights, or they can take some rights allowed under statutes away. Um, if you're a tenant who has an oral lease, you want to make sure that you take steps to document what the terms of that agreement are. So either you know try to put in writing or try to get some acknowledgement from your landlord. That way, if there is a dispute about the terms, you have some form of documentation, some form of evidence that you can use, basically to prove your side of the story. Um, as we said, the lease terms are really important in any landlord-tenant relationship. They're going to control in the vast majority of disputes, and they're going to tell you a lot. Some basic terms that you'll see in most, if not all, leases. Most leases, if not all leases, will have some form of monthly rent. The lease will let you know how much to pay, where to make payments, and when to make payments. Um, it could assign late fees if you are late on making payment of rent, and could assign other fees. Additionally, most leases that are in writing, they're standardized, will have some form of clause that will specify how payments are to be applied. Keep in mind, monthly rent is considered different than utility payments, but these clauses basically allow the landlord to take any money that you give for utility to pay for rent instead if you're behind on rent. So be aware of that. Leases are going to establish an initial lease term. Like I said, most of these are going to be for a set period of time. Um, in some cases, you will end up with month-to-month leases just outright. In our cases, there are leases that will go for a period of time, and then if there isn't another signed lease, it'll automatically renew month to month. A clause renewing month to month will establish what those terms will be. Usually it specifies that the terms are going to be the same as the original lease. Oftentimes, you'll also see something where going on month to month will allow the landlord to assess additional fees. The lease will also usually include some reference to committee rules and policies, oftentimes incorporating those rules into the lease itself. It'll also have signed addendums. So if you're paying for utilities and the lease itself doesn't specify what that looks like, you'll usually see a utility addendum. Or you may see an addendum if you have pets, specifying what the terms of pet ownership are going to be on the property. Additionally, if you're on a public housing voucher or you're in a public housing facility, usually you do see either a HUD or housing authority agreement as part of the signed addendums. Leases are also going to specify what constitutes a default on the lease. So these can be things like failure to pay rent. It might specify that failure to abide by committee rules and policies is the default of the lease. It'll also provide information on how to terminate your lease early and what sort of penalties might be incurred there, or it might give information about what happens if the lease comes to an end and the landlord wants you to leave. Finally, the lease may include information about timelines. So, for instance, it may provide you a deadline for renewing your lease or providing a notice of non-renewal. It also may provide specific timelines for giving notices of default or giving a notice of vacate. And we'll talk about notice to vacate. That's sort of the first document that exists that you'll get if an eviction process is starting. A lease agreement can actually alter the amount of time that the landlord has to give you under a notice to vacate. So be aware of that. So we want to talk about terminating the lease because that's sort of the crux of what we're going to be talking about when we talk about evictions. most leases are terminated at the end of the lease term. So after initial term, either party has the right to say, I want to leave, or we no longer want to rent to you. They do need to give proper notices under the timelines agreed to by lease. I believe under the code, the statute provides for a 30-day notice. However, those notice timelines can be altered by the lease itself. If you fail to leave after the deadline to leave under the termination, that's what makes you a holdover tenant. We'll talk about holdover eviction shortly. We often get questions about what happens if the landlord terminates the lease but the tenant doesn't want to leave. The reality is that under Texas law, except in very specific circumstances, you can't make the landlord renew your lease, just like the landlord can't make you renew your lease. So, this is oftentimes a no-fault sort of situation. So long as it's the end of the lease term and the landlord provides the proper notices, generally speaking, there aren't grounds to challenge the termination. Now, the other type of termination that we see is an early termination of the lease. That's a termination that happens during the initial term of the lease. We can see this in a number of ways. The first way to talk about is the tenant decides they want to leave early, and so they provide the landlord notice of early termination. Unless the lease allows you that right, oftentimes it's a form of breaking the lease. You want to read your lease to see if it deals with that sort of situation. Oftentimes we see that there are certain penalties that can be assessed against the tenant if the tenant terminates the lease early. Now, under the code, in specific circumstances, the code actually do provide the tenant the right to terminate the lease without penalty. And so we'll talk about these here. Keep in mind that we're going to be referencing codes. The codes are going to provide specific information about the circumstances that allow a tenant the right to terminate early. It's also going to provide information about what sort of notice needs to be provided. And almost all of these cases, you need to provide some form of notice. So if you're in a situation and any of these apply to you, before you do anything to terminate, read the code, see what's required in order to exercise your rights. So the first type of termination that we see is family violence. That's something that cannot be waived by the tenant in the lease. Same thing with instances where you have victims of sexual offenses or stalking. There's a right to early termination. Those also cannot be waived. If a tenant dies, the estate does have the right to terminate to avoid future liability, but they may be obligated to pay any past due obligations. And then in certain cases, people who are in active service military have a right to early termination, although the landlord and the tenant can agree to waive the right in certain circumstances. Now, in addition to reading the statutes themselves, keep in mind that if you're in a situation where you exercise your right and the landlord refuses to allow you to terminate early without penalty, there may be causes of action that you can bring against the landlord to enforce your rights. So just refer to the code if any of these apply to you. Another type of early termination that we unfortunately see a lot is we call casualty loss situations. So casualty loss is any sort, you might want to think about it as sort of a natural disaster affecting the property. So if a hurricane comes down and knocks off the roof, or if there's a fire and it renders the property unusable, there could be rights to early termination. So the key tests here are whether the casualty loss makes the premises totally unusable for residential purposes, and the loss is not related to the tenant's fault or negligence. In those cases, the tenant has the right to terminate the lease under 92.0054B. Keep in mind that that same code also provides the landlord the right to terminate the lease if the premises are made totally unusable. So it cuts both ways. Totally unusable is the key thing, though, because if the premise is made only partially unusable due to a casualty loss, there is no right to early terminate the lease. The tenant could petition certain courts for a reduction in rent, however. Likewise, the landlord does not have the right to terminate the lease just because the premises were made partially unusable. Whether the damage makes it totally or partially unusable, that's going to be a question of fact if there is a dispute. So the court would, hearing any sort of dispute on that issue, would be able to decide that case. This is one area where if you're facing this sort of situation, you should probably talk to a lawyer. Keep in mind too, this is one form of early termination that can actually be waived or altered by the lease. So you want to refer to your lease as well as the code to see if you would have a right should you be facing this sort of situation. And now we come to the meat of what we're going to be talking about today. Most evictions are going to involve terminations of the lease due to a breach of the lease. So what's a breach of the lease? A breach of the lease is going to be any violation of the lease terms, condition, rules, or other provisions. Your lease is going to define what the breach of the lease looks like. The most common of these sorts of defaults or breaches are failure to pay rent, violations of community policies or community rules, having unauthorized tenants living in the apartment, any criminal activity, or technically holding over is considered a default to the lease, even though the lease is no longer in effect. If a breach of the lease occurs, the landlord, has to basically note it, and they have to give you a notice to vacate before filing the eviction. Now, keep in mind, the notice to vacate does not need to specify the specific grounds for the eviction, but does need to provide you notice that they're going to be seeking an eviction. We'll talk about that next. Before we get to that, though, some special circumstances that we sometimes see. We sometimes see tenants who are having issues with their landlord, specifically in regards to failure to get repairs done. We see tenants refusing to pay their rent and saying that we shouldn't have to pay for the rent unless we get these repairs. That is a very bad idea under Texas law. Texas law requires that rent is paid in full and on time as it comes due. Withholding or refusing to pay rent could subject you to an eviction for non-payment of rent. And, the lack of repairs is not a ground to defend that eviction. Additionally, in order to actually have a right under the code to get repairs, you need to be current on your rent. Once you fall behind, the code specific, your landlord does not have an obligation to fix your apartment. If you're having issues obtaining repairs under the lease, there is a process by which the tenant can demand repairs and bring a lawsuit against the landlord. The first thing to do is to send the landlord a written request. We recommend doing this by certified mail. Basically demanding that the landlord make repairs under the lease. The tenant then has to wait a reasonable amount of time. Reasonable under the code is usually assumed to be 10 days, although it could be a shorter period of time if it's an emergency sort of situation, or a longer period of time if the resources to repair the property are not available. So for instance, after a hurricane, if the landlord wants to make repairs but can't hire a contractor because they're all booked up, that could be a valid reason why repairs aren't made within that reasonable period of time. Once the timeline ends, you basically have the right to go to court and file a lawsuit to get relief in that situation. This is an instance in which we recommend that you talk to an attorney prior to filing a lawsuit. There are nuances in how this is done and how this is documented. And in certain cases, the lawyer could actually be entitled to attorney's fees, which means that you might be able to get a private attorney to handle one of these cases. So if you can't get legal aid to look at it, there may be the ability to get a private attorney to do it. Another special case, what happens if the tenant tenders rent timely and in full, and the landlord refuses the rent? We don't see this too often, but we do see it often enough that it gives us concern, and we want to talk about it for a little bit. The landlord is not free to refuse properly tendered rent pursuant to a lease agreement. The landlord could refuse rent if rent is partial payment, or if the rent is late, or if the lease has been terminated. Landlords also have the right to determine the manner in which amounts are paid. So they could specify that they don't want to take cash, they want to take a money order, or that things need to be paid through a portal or through some other method. So there are some nuances in terms of, when the landlord does take payments and when the landlord might be able to refuse a payment. Tenants who have had their timely rent refused should do the following. The first thing is you need to review your lease and your ledger. You want to make sure that you're making the full payment, including not only the rent, but also utilities or other charges. You also want to make sure that you're tendering it in a manner that's consistent with the lease. If the lease specifies that they want you to pay money orders, won't accept anything else, you can't go and pay it with a personal check or some other way. Assuming that everything on your end is correct, you want to document the date and the manner of the payment. It may make sense to send an email to your landlord stating that you've tried to make the payment, but that's been refused, or, basically asking, what steps they want you to take. Obviously document that correspondence. If there is a dispute about what happened and when, the correspondence is going to be your best friend in terms of proving your side of the story. You want to keep the payment or funds available for payment later. Um, you know, you don't always know why something's been refused. But if you don't keep the payment available and there's the possibility to settle or there's a further dispute, it could put you in a worse position. So treat the money that you're going to use on rent as though it's already spoken for. Don't spend it on something else. If this situation continues, you want to continue to offer rent in full and on time for future months. And you do want to contact an attorney for assistance. They can provide you more specific information. In this sort of case, just to emphasize this, documentation is critical. If you say that I tried to make a payment to the landlord, refused, but you haven't documented it, it's not hard for a landlord to file an eviction and for a judge to get the question of who's in the right and wrong. You also want to make sure that you're tendering rent, even if the landlord verbally or in writing says they refused the rent. A lot of judges are going to look at the tendering of rent as being sort of the red line of whether or not you're complying with the lease or not complying with the lease. And finally, sometimes we see an instance in which there's a dispute about the proper amount to be paid. Like maybe there's a utility bill that's higher than it should have been, or maybe the landlord is assessing fines or fees that they really shouldn't be able to. It oftentimes makes more sense for the tenant to make the payments if they can up front in the amounts the landlord is asking for, and then pursuing the landlord for improperly charging them, than withholding amounts that might be properly owed and then dealing with an eviction. It's a lot easier for the tenant to get the relief they need going on the offense than trying to defend an eviction. Now we get to the notice to vacate. So as I mentioned, this is the first document in any eviction. The code requires that a notice to vacate be provided to the tenant, basically demanding possession of the property back before an eviction is filed. Under the code, there is a requirement that the landlord give 3 days notice, but that is a timeline that can be altered by the lease. Right now, the Texas Apartment Association lease, which is an industry standard among a lot of the bigger apartment complexes, they allow for a 24-hour notice to vacate. So the lease is going to determine whether or not that 3-day notice timeline is in effect or some other timeline is in effect. The code, however, does define what proper delivery is, and this cannot be waived by the lease. So the code requires the notice to be delivered in one of 4 ways. So the first way is they can hand deliver it to you. What that means is that somebody knocks on your door, you open it, and they hand you the copy of the notice. They can send it to you via regular, registered, or certified mail, or they can post it on the inside of the door, which means they open the door, they tape it to the inside of the front door, and they close it and move on. There is an alternative way of serving this, which allows them to post on the outside of the door. They have to put in an envelope, they have to firmly fix it to the outside of the door, and then to mail it to you by 5 the same day. They're also only allowed to do this in particular cases with particular circumstances. Usually it is a case where the landlord does not have the ability to access the apartment without the tenant being present. So for instance, if there's a deadbolt and they couldn't enter, then that gives them the right to post on the outside of the door. Or if there's a dog in the unit, that may be a reason that they could use the alternative. Notice is surprisingly important right now in eviction law. An improperly delivered notice is fatal to the case. And so documentation is very important. If you're worried that your landlord may be trying to evict you and you're waiting for that notice, it's important that you're prepared to document exactly how you received the notice. So, if you go home and there's an envelope on the outside of the door, you want to take a picture of the envelope, take a picture of how you found it. If there's something shoved in your door jamb, you want to take a video of you retrieving the notice from the door jamb. That documentation can be the difference between you winning your eviction case and losing your eviction case. So another special case that we often see are what we call CARES Act issues. So as we stated, the code requires a 3-day notice to vacate. That can be altered to a 1-day or whatever sort of timeline the landlord wants under Texas law. Where federal law has a specific requirement for some properties. We call these covered properties. These are basically any properties that participate in any sort of federal subsidy. So the first type of those are going to be programs that are we call covered programs under the Violence Against Women Act. These properties get some form of federal funding, usually through something like a Section 8 housing voucher or low-income housing tax credit, some project-based housing, rapid rehousing. Basically anyone who's receiving some form of housing subsidy could be covered property under this part of the program. The other thing that we see are any federally backed mortgages that a property might have could make it subject to the CARES Act. So if they have a Freddie Mac mortgage, Fannie Mae mortgage, veterans mortgage, that could be federally backed, that could subject to the CARES Act. If they are covered property under the CARES Act, they are required to give a 30-day notice to vacate before filing. This is a situation where if you think you might be dealing with a CARES Act issue, you should talk to an attorney for a few different reasons. The first is that there are some databases out there that have this information you can quickly search, but those databases aren't always the most user-friendly. They're not always up to date. The gold standard for checking whether or not there is a federally backed mortgage, for instance, is going to be checking the real property records, and that's not something most people know how to do. Likewise, any of these federal programs, the best way of proving up that they're participating in those programs is going to be either filing in the property records or by asking for that information from the housing authority. And so an attorney can assist you with that. Additionally, the CARES Act originally was a COVID era policy that has sort of extended to the present through how that law was written. There are some landlord attorneys who want to argue that this act no longer has any effect. We're confident, according to the case law, that it is in effect, but it's a sort of thing where if you do run into somebody who claims that this isn't in effect, you want to see if you can get an attorney who can argue that side of the case for you. So finally, we arrive at evictions proper. So an eviction, as we say colloquially, or forcible detainer suit, as is sort of the legal term for this sort of lawsuit, it is a lawsuit that a landlord brings to retain possession of the property. The main elements that a landlord must prove, they have to prove ownership, they have to show a breach of the lease, they have to show they gave proper notice, and then finally they have to show that the defendant refused to leave. Important to note, if the notice to vacate was delivered and you leave prior to the deadline on the notice, the landlord actually cannot file the eviction against you. Likewise, if the landlord files the eviction prior to the notice to vacate expiration deadline happening, that is also an improper eviction. So the date where the lawsuit was filed is really important. Most evictions are going to be for non-payment of rent. In those specific circumstances, the landlord can add a claim for back rent amounts. They can only ask for the back rent. They can't ask for any amount such as late fees or past due utilities or any other sums that might otherwise be owed. They would have to bring those in separate lawsuit. In an eviction based on conduct, so violation of community rules or such, or holdover, they are allowed to ask for court costs and attorney's fees the same way they could in a non-payment of rent eviction, but they can't get damages in terms of back rent or anything like that. We do get asked sometimes about whether jury trials are available in evictions. You do have the right to request a jury. You would need to file the request and pay the fee or get a fee waiver on file at least 3 days prior to the eviction trial date. If there's an instance in which you do that and for whatever reason the court refuses to have the eviction via jury trial, you should contact an attorney. That is a situation where there may be something to be done to compel the jury trial. So all evictions are going to start in the justice courts. These are sort of the lowest level courts in the state in terms of how they're set up. Basically, they're designed to be open and available to anybody without an attorney so that they can go in and get their case heard and get justice done. The reality of that theory can be a little bit different, but because it's meant to be sort of the first rung of the process, it's supposed to be open, they're going to use simplified rules. They don't have to follow the sort of normal evidentiary rules that you might see in the higher courts. And so because there are sort of these more informal processes and rules, what this looks like is going to differ from court to court. So just be aware, I'm going to talk in generalities. Oftentimes, there are a lot of differences between courts, not merely within the county, but even within individual precincts. In Harris County, there are 8 precincts. Each precinct has 2 justices of the peace. If you are in a precinct and your landlord wants to evict you, they can go to either of those places, not just the one closest to where you live. And again, though the processes, well, not with the processes, but like what this looks like can look very different even within those 2 different courts in the same precinct. If you're going to trial, you want to arrive on time and have everything you need. I see too many instances in which somebody shows up to trial and they say they have evidence of payment, but they didn't bring it with them. You want to come prepared. When you show up, you want to check in. Some courts are going to do what they call a docket call. So everybody in the courtroom waits, and then the court just calls the cases at the very beginning to have everyone announce their presence. Other courts will have the clerks check you in, so they'll note ahead of time whether or not you're present. If you're confused about which your particular court is using, just talk to the clerk. They'll give you the information. Additionally, arriving early gives you an opportunity not only to check in, but there are some courts that have resources available to you prior to trial. So for instance, I just got out of a court today that had us basically available at the court to provide additional legal information or if we wanted to represent people. So, you want to be on time, you don't want to miss that docket call, and you want to be there early enough to take advantage of any of the resources that might be available. Prior to the case being called, a couple of different things might happen. There are some judges that give instructions on how the court works. You're going to want to listen to those to provide additional information how this process is going to look on that day. There are other courts that they ask that the parties confer prior to going to trial. And we'll talk about what settlements look like, but basically it gives you an opportunity to talk to your landlord, see if you can work something out, without having to actually go in front of the judge and risk judgment. Once your case gets called, the way this works is the judge generally calls up both parties. They hear the plaintiff's case first. So the plaintiff will give testimony about different things in their case. Once the plaintiff is done, the defendant can have the right to ask questions, and then the defendant will have an opportunity to respond. Keep in mind that the judge may ask questions, or they may want you to provide evidence for your defense. So you want to be prepared to provide any information the judge is asking for. You may also want to be prepared to answer any questions your landlord may have, because they do have the right to cross-examine you if there's a dispute of the facts. At the end of the trial, the judge is going to issue a judgment in favor of one party or the other, or they'll dismiss the case. If you can, you want to get a copy of the judgment for your records and for your files. It'll tell you more on sort of what the judgment actually looks like. Sometimes the judge ruling from the bench isn't as clear as we would like them to be, but the written order is basically give the information about what the final decision was. We do sometimes get questions about whether or not the court will have the opportunity to reset the case. Generally speaking, the court can only reset the case 1 week without the parties agreeing, or if the parties do agree, they can reset it for longer. Additionally, a plaintiff does have the right to ask for a reset. The defendant does not. We also do sometimes get questions about what happens if you need special accommodations. Basically, if you need something like a Zoom hearing because you can't make it to court, you want to reach out to the court ahead of time and find out what sort of they will allow. The rules do give the courts a lot of leeway in determining how they're going to allow you to appear. There are some courts that are very permissive in terms of Zoom hearings. There are other courts that they're somewhat permissive, but they want you to show good cause. And then there are other courts that are skeptical, and you will really need to document that you need the Zoom hearing before they'll consider it. So it makes sense to reach out ahead of time to try and find out, what you'll need to show if you're not able to physically appear, but if you want to appear virtually. So settlement agreements, like we discussed, there are a lot of judges who want to see the parties confer prior to trial. It often makes sense to also talk to your landlord before you get too far down this process, see if anything can be worked out. It's oftentimes, there's some version of an agreement that can be entered into by both parties that will resolve the issues or give parties clarity about what needs to be done. Some courts even provide resources to facilitate the settlement, such as providing a standard settlement form, or even providing mediators, which is a third party who can basically talk to both sides and try to get them to agree to something. It's important to note that a settlement agreement requires both parties to agree to specific terms. The parties determine what those terms are. A good agreement is going to clearly define what the actions are that both parties need to take. And, it'll provide information about what happens if a party breaches part of the agreement. So just to give you an example, we often see move-out agreements where one party needs a specific amount of time to leave, and they're asking the other party to give them that time while agreeing to dismiss the case if they leave by a particular date. A good agreement is going to define that the tenant will leave, what date the tenant will leave, and it'll provide basically the landlord some form of recourse if the tenant doesn't leave by that time. It will also specify that the landlord will dismiss the case if the tenant agrees to leave, and leaves by that particular date. Really important. Like I said, a lot of courts provide standard settlement agreements. Some even provide recommended dates for someone to leave. Before signing any sort of standard agreement, you want to review what those terms are and make sure that they reflect exactly what you're agreeing to do. I've seen cases where one party thinks they're entering into a payment plan that allows them to stay when The way the settlement agreement actually reads is that they're agreeing to make a payment and then also leave in exchange for dismissal. And so, obviously those are two very different things. And you don't want to end up in a situation where you think you're agreeing to one thing and the text of the agreement, which is going to control in any sort of dispute, says something totally different. Also important to note, any form of settlement needs to be in writing, it needs to be signed by the parties, it should be filed by the court. Well, filed with the court, rather. Um, we live in a world in which some people want to do things via handshake deals, and while informal agreements are great, they're not enforceable. If you're going to be settling, it needs to be in writing, it needs to be specific, it needs to be filed, it needs to be signed by everyone. Keep in mind, too, all settlement agreements are going to involve parties giving up rights, and may also impose penalties if a party fails to comply with the agreement. So the classic thing here is if you go to JP court, you enter into a settlement agreement, and the settlement agreement says that you're waiving the right to appeal, you may be waiving the right to appeal, or same thing in county court, or you may be waiving the right to even have your defenses heard. So settlement agreement isn't just something that you can use to delay for time and then go back on because it's inconvenient. If you agree to this, you have to do what the agreement requires, or else there could be significant consequences. I guess as a final note, I'd mentioned, we want to review the standard agreements. Keep in mind, while the formal requirements are that the agreement is in writing and signed by the parties, and while a good agreement is going to be specific, you can technically write up your own agreement. You don't need to use standard forms, or you can alter standard forms if there are terms you need to add or there are terms you need to change. So just be aware of that. The court needs to know what's being agreed to in writing, but don't feel like you're bound to sign on to sort of standardized form just because the form says specific things. You're free to alter it, say exactly what you need it to say. So let's talk about what happens if you go to JP court and you lose, but you still want additional time or you need to challenge the decision. In Texas, because the Justice of the Peace courts are courts that don't take records, where there's no court reporter recording what happens, you do have a right to what we call de novo appeal. That is a brand new appeal from the top. Basically, the court hears the case from the beginning, and most of what happened in JP court doesn't actually matter to the decision that's going to be handed down in county court if you appeal. The way to appeal a decision is within 5 days of the trial judgment, you need to submit either something called a statement of inability to afford court costs and fees, or you need to pay something called an appeal bond, which is normally set at 2 months of rent. Most people who are being evicted for non-payment of rent. If you can't afford to pay your rent 1 month, you're probably not going to be able to pay 2 months to the court up front. So most people appeal via the statement of inability, or the IFP. If you don't file your appeal within that 5 days, you lose the ability to appeal, and the writ of possession, which is the document that allows the constable to remove you, that can be issued. If you do file it within 5 days, if you're being evicted for non-payment of rent, you need to make a payment of 1 month of rent to the court registry. Basically, that is an amount that is going to pay for rent for the month that you're presently in. You also need to make preparations to make payments of 1 month of rent for the next month, basically within the first 5 days of the next month. Basically, the code requires that you keep current on rent while the appeal is going up. If you don't make that payment, you still have the right to appeal, but you should be aware your landlord does have the right to get possession of their property back, and so they can ask for an early writ of possession. Once you've appealed and once those 5 days to pay the rent at the court registry have passed, the cases get transferred up to the county court at law, and they're assigned to a court. You'll receive paperwork in the mail, so it makes sense to check it regularly. There is a requirement and something that's stated in the letters from the county court saying that you need to file a separate answer. It is often prudent to file an answer with the county court, but it's not necessary to avoid a default if you file the appeal with the statement of inability form. So just be aware, if you see something like that which says you have a certain amount of time to file an answer, it makes sense to do so. It's not strictly necessary in order to preserve your rights. So just be aware of that. Um, like I said, in county court on appeal, the case is heard again from the beginning. It means your landlord has to prove up their case all over again. And it means you have a brand new opportunity to provide defenses. Um, most defenses are going to be to basically elements of the case. In certain instances, you may need to file we call specific denial, or, well, really rather affirmative defenses in your answer if you file it, which allege specific things. If you think you might have affirmative defenses, you should talk to an attorney for additional information. Keep in mind, county courts use formal rules of procedure and evidence. It's going to be look a lot different from what you see in justice of the peace courts, and it's a lot more standardized across the different courts. Like I said, justice of the peace courts are not courts of record, so there's no need to tell the judge what happened last time. But you do want to pay attention to what the plaintiff is doing, because if they fail to prove up their case, that can be grounds for a dismissal. Additionally, landlords need to prove up their case with testimony and evidence. In JP court, oftentimes they can get a judgment simply by testifying that something happened, or they may be able to provide a document in a less formal way than they need to in county court. In county court, though, they need to specifically adhere to the rules of evidence, which means if they don't do that, then they may fail to prove up their case, and that may mean that they can't get judgment. If you haven't picked up on this already, because county court is a little bit different than JP court, because it's meant to be more formal, this is a case where if you need help on any of this, it makes sense to ask for an attorney or to, seek assistance from us. If you're unsuccessful in county court, you're going to have 10 days to pay an appeal bond. We call that supersedeas bond. Most people can't afford to pay that. It's usually set at 8 to 10 months of rent. But what that period basically does, it means that if there's a judgment against you, you have 10 days to leave before writ of possession can be issued. Some courts, however, are going to allow for immediate writ of possession if you're behind on the payments to the court registry. So just be aware of that. There should be a separate motion filed in those instances, though, so you will get advance notice about whether they're asking for immediate possession or not. So let's talk briefly about some special cases in regards to public housing and subsidized housing. Because there are actually quite a few defenses available to subsidized housing tenants that aren't available to most tenants. One of these is that there are additional termination requirements. These are going to be spelled out in your HAP contract and federal regulations. There are also specific things that your landlord can't require on appeal if your housing is subsidized. So for instance, if you have a Section 8 housing voucher and the landlord is trying to evict you for non-payment of rent, and you only owe $100 under the HAP contract, and the landlord asks that you pay the full amount, the landlord is not allowed to do that. You're only required to pay your share of the tenant rent into the court registry, and you're only liable for that amount so long as your agreement with the housing authority is still in place. Like we said, all public housing beneficiaries are probably covered by CARES Act protections as well, which means that there are 30-day notice requirements. If there are any issues with this is an instance in which you want to reach out to an attorney to get additional assistance. Like I said, there are quite a few different defenses that can be raised with different procedural issues that might arise. It's going to differ from program to program, though. So you want to get as much specific information as you can, and that usually means talking to an attorney for assistance. So that kind of wraps up the eviction side of this. We did want to talk about what else might happen if a lease agreement is breached. Under Texas law, landlords are not allowed to do what we call self-help remedies. Basically, this means either, trying to evict someone themselves by locking them out, or by trying to force them out constructively through something like shutting off utilities. Um, so we want to go through both of those. They're similar, so we're going to handle both of them at the same time, and a lot of this is going to be repeating myself. But basically, your landlord's not allowed to exclude you from the house or the home unless there are repairs being made or there's an emergency, unless they're removing content abandoned by the tenant, unless the tenant's behind on rent, and there's a specific right to change the locks under the lease. And notice is properly issued under the property code. I should mention this is not what we call a permanent eviction or self-help remedy, the way sort of a wrongful eviction is. We'll talk about it a little bit. Basically, it's meant to be a way in which the landlord can force the tenant to talk to them. And finally, they can exclude you if basically they get rid of possessions, judicial process allows. Utility shut off. Again, they can't interrupt your services unless there are bona fide repairs, construction emergency, or unless there's a specific part of the lease that allows them to do that and property code is strictly followed. Again, for both 92.008 and 92.0081, these parts of codes are very specific. I've yet to see a landlord do these correctly. Most don't even try. So you're very rarely going to be dealing with those. So we'll only spend limited time talking about that. But just be aware there's technically a way under the code in which that might be authorized. It's just probably not going to be done correctly if you see it. It's something to talk to an attorney about. So let's say you're dealing with any of these issues. Even if you're behind on rent payments and the landlord tries a self-help remedy, you actually have the right to sue your landlord to get service restored or to get access to the property again. If you're talking about lockout, we call that a writ of reentry. If you're talking about a utility shutoff, we call that writ of restoration. The lawsuit's filed in a precinct where you live. There is technically a filing fee, but that can be waived by filing a statement of inability to afford court costs. It's technically the same form that you would use to appeal an eviction suit, but it's filed alongside your petition, basically to get the court to waive any amounts. So when you've been locked out, the landlord cannot lock you out unless there is some allowance in the lease that allows them to lock you out under 92.081. And what that basically looks like is they give you advance notice they're going to be changing the locks. And then when the locks are changed, they provide notice about how to get a copy of the new keys. That request has to be honored within 2 hours of when the request is made. And this is why you almost never see these sorts of lockouts. If your landlord tries to lock you out, changes the locks, and provides you notice that you can get a copy of the keys by calling a particular number, and you're out that day, and you come home at 2 a.m., and you make the call at 2 a.m., they have to hand you the keys by 4 a.m., or else they're in violation of the code, and then you have a cause of action against them. It's that specific. If they fail to let you in or you remain locked out, at that point you file the writ of reentry lawsuit. You start by filing a petition laying out the facts. The facts are sworn to under oath. Once the case is filed, it's originally set for what we call an ex parte hearing, which basically means that you don't need to go through the formal process of serving the landlord. It's usually best practice to give them some sort of notice the hearing is happening. A lot of judges want you to communicate with the landlord either before the notice is filed or after. That way, you're not just rushing to the court, you're actually trying to resolve it yourself before they need to step in. But it's not a formal requirement that they be formally served before you get your hearing. At the hearing, you're going to tell the judge your side of the story. If the judge agrees you're legally locked out, they issue an ex parte writ of reentry, ordering the landlord to let you back in the home. The constable then serves that writ on the landlord. There is a process where if the landlord wants to challenge that, they can file a response and ask for a new hearing. But at that point you go and you basically tell your side of the story, they tell their side of the story, and the judge makes a determination. However, by that point, you should already be back in the unit under the writ. Separate from the writ of reentry, if you go through this process and there are damages incurred, that can either be loss of property or you had to spend money to either stay somewhere or because you didn't have access to your property, you can bring a separate lawsuit to recover damages. And we recommend doing that as opposed to asking for damages in a writ of reentry lawsuit. That way you know what your damages are and you're not locking yourself out to any future damages caused by the lockout. The civil penalties are 1 month's rent, $1,000, any actual damages or expenses, court costs, and reasonable attorney's fees, less any delinquent sums of rent or other sums. So in other words, if your landlord goes through this process, and they find that it was done improperly, you get your writ, you sue them, you can get these damages, and it could either be bounced against your sheet, your ledger, or it could, possibly be that your landlord would owe you money. There's also an option under the code to terminate the lease after writ of reentry has been granted. Utilities are basically the same. If your landlord illegally disconnects the utilities, you file the writ of restoration lawsuit. The case is set for an ex parte hearing. Best practice is to let the landlord know what's happening, but they don't need to be formally served. You go to the hearing, you tell the judge your side of the story. If the judge agrees they were illegally disconnected, you receive the writ of restoration, which gets served on the landlord by the constable. And again, you can recover damages basically similar to what you'd be able to get with the writ of reentry. The final question we get is what happens when we talk about security deposits in sort of landlord-tenant dispute? This is a separate issue from an eviction or from any sort of lockout or utility shutoff. A security deposit is basically an amount that is paid to cover any damages that might be incurred on the property through tenants' neglect or through basically intentional damages. The landlord is entitled to keep or deduct from the security deposit any amounts for the damages or charges for which the tenant's legally liable. Or, if there are, let me rephrase that. If there are any physical damages to the property, so any, like you put a hole in the wall or something like that, they can keep, the amount to be used for repairs of that. Or if you're behind on rent when you leave, the security deposit can be kept in order to cover those amounts. Anything that the landlord is not entitled to keep, they have an obligation to return. They're required to return that on or before the 30th day after the tenant surrenders the unit, so long as the landlord has a forwarding address for the tenant. If you don't give your landlord a forwarding address, they still have an obligation to return the deposit, but that timeline does not start ticking. The landlord cannot retain any portion to cover normal wear or tear. And if they are going to be keeping part or all of the security deposit, they do need to send you a written description, itemized list of any and all deductions. So be aware that if you're leaving and there are no damages to the property, or the damages are less than the amount for the security deposit, or there are no amounts owed, and the landlord refuses to give you the security deposit back and does not provide you the list of deductions, you can send them a demand letter basically asking for the deposit back. If they still don't return it, you do have the right to file an affirmative case. Additionally, if you disagree with the list of deductions, you can also go through the process of filing a case to try and get the deposit back. This is going to be one instance, and again, where we're going to recommend if you're thinking about filing a case that you talk to an attorney. There are some nuances here and some procedures that need to be followed in order to do this successfully. And then the code actually provides attorney's fees in a suit to recover a security deposit. And then there are additional damages that you may be entitled to beyond just the amount improperly held. So, sort of thing where, it makes sense to do it right. And you may be able to find even a private attorney to do this, even if legal aid looks at it and can't take it. So just some additional tips before we let you go. If you're dealing with a landlord-tenant issue, it always makes sense to try and get ahead of the problem. Talk to your landlord as soon as an issue arises. Try to figure out a way to avoid litigation if you can. We get questions about rental assistance. There may still be some available. You want to check with your local organizations. I know the city has had a small pot for a short period of time. If you call 211, they may be able to give you more information about that. If you're having any issues with the condition of the unit, pay for your rent and then contact someone for help. When in doubt, ask for help. And seek help from credible groups such as Lone Star Legal Aid or Houston Volunteer Lawyers or someone who does this work. There are some groups out there that don't do a good job or aren't interested in assisting tenants. And so just make sure that you're going to somebody who has experience doing this sort of work if you're looking for that assistance. And that concludes our presentation. If you would like to apply for our services, we have the phone numbers at the bottom, or you can go to our website, lonestarlegalaid.org. And I'm ready to take any questions you guys might have.
Okay, let me see here. I actually don't have any questions in the chat. That's a first. We haven't had that in a minute. We haven't had any questions in the chat.
I know I didn't do that good a job of covering the material.
Hey, maybe you did. Maybe you did. I'm double checking on social media to see if we got anything. But in the meantime, while I'm checking that, do you mind kind of going over again when I heard you kind of explaining about the when you were in the appeals process that the landlord, you're still required to pay your rent to the courts. If you miss
Yes,
your rent payment, that the landlord can still file for uh,
writ of possession.
a writ of possession.
Yeah.
So
So
they can still basically put you out in the meantime while you're still appealing. Am I
yeah,
getting that correctly?
yeah. So the way to think about this is that someone who is appealing a case, is basically looking to stay, while the appeal is going on. And that puts the landlord in non-payment of rent case at sort of a weird position because on one hand, there's a due process right to have the county court hear this. But on the other hand, the landlord has gone to court, has gotten a judgment, you know, isn't getting paid potentially. And they have an interest in making sure that the tenant's not just doing this to extend the period of time they can be there without making payments, because that hurts them. Meanwhile, the tenant has an interest in making sure that if they are making payments in full and on time under the code, that the landlord doesn't refuse those or doesn't take them but lie about them or do any sort of unsavory thing with them. So both parties have something of an interest that you know if something's going to be paid, that's properly paid and properly attributed. So what the court does is they step in and they say, we're going to act as the middleman. Tenant, you pay us 1 month of rent, and that'll secure your possession of the property. We know rent's been paid, so the landlord's not prejudiced, so there's no issue with you staying there while this appeal goes up. Landlord, we're going to hold on to this while the case is going up, but you're entitled to this payment. It pays for the rent for these months. And then basically, as long as you're keeping current, the idea is that you're meeting your obligations under the lease. If the tenant doesn't make those payments, then it's sort of prima facie evidence that they haven't been meeting the terms of the lease. And so at that point, default would basically mean, tenant broke the lease and the landlord would be entitled to possession.
Gotcha.
Yeah. So I mean, that's the theory. There are some issues with it, but like if you're thinking about why do I have to make these payments while the appeal is going on, code requires it, and that's where the theory behind it. But
So the
yeah,
land, so the landlord, future wise, for landlords that are kind of out there, that doesn't mean that they're not going to get paid. It's just the court holds it until the a whole appeals process is done.
well, technically, the
Or
landlord can,
who gets the money?
yeah, so technically the landlord can ask for it as soon as it's been paid.
Okay, gotcha.
So, like, again, the idea is that you're making sure that the tenant is keeping current with their obligations. And then the landlord would be entitled to it because the tenant is there. They get to go get that. And if the tenant defaults under that, the idea is that they've had enough notice. They've had the opportunity to be heard. You know, they landlord would be entitled to get the possession of the property back. Now, if the tenant, let's say, and I've seen this before, where the tenant, there's an issue with the eviction or there's an issue with the amount owed, and the tenant wants to appeal, but the tenant's also halfway out the door anyway. Tenant can appeal, leave, and they don't need to make those payments. The payments aren't necessary to perfect the appeal. They're not necessary to keep the appeal going up. Um, it's just if you intend to remain there, the court wants you to be current on rent, so to speak.
Makes sense. Makes sense. I just wanted to kind of put that out there for those folks, for those landlords that may be listening. They're like, "What? You're gonna bill, and they gotta hold my money, and I'm not gonna get paid, and blah blah." I don't
Yeah,
want them to. I don't want them to think that. Okay.
yeah.
Can you also reiterate again about, because I still get people that I come across that will say, well, I only got 3 days to leave. I got my notice and I got to be gone in 3 days. That
Mhm.
they really still think that the notice to vacate means
Yeah.
that you got to get out, got to go.
So the notice is, basically the first step in getting the eviction, but it's not an order requiring you to leave. Now, there are instances in which it may make sense for you to leave, but if you're still there after that time, you know, you're not going to be legally locked out. You're not going to get constable to remove you and your stuff. The next step would be to be served with a citation letting you know when the eviction trial date is going to be. And so, no, you don't need to leave within those 3 days. It may make sense to do that, but you know, the landlord can't kick you out just because you received that notice and didn't leave within that time frame.
For somebody that gets an eviction notice and they are basically kind of looking for an out or whatever, or they want to leave, can the landlord still come after them if there is a remaining amount of time that's on their uh, lease? So say for instance it's 8 months in, you still got 4 months left on your lease. Can they sue you for, if they evicted you, can they sue you for what's left of the remaining amount of your lease?
It depends. There are some leases that have acceleration clauses that say that you know, they can choose to ask for the amount of rent that would be owed on the contract, at the time of termination. I rarely see that actually enforced most because, first of all, there's a requirement for the landlord to mitigate their damages in those instances. It's also, we rarely see small claims cases, if ever see small claims cases, dealing with non-payment of rent or other sums. Usually what happens is that any amounts that are owed are going to be sent to a credit reporting agency, or they'll be sold off as third-party debt. And, it's a headache, but it's not a lawsuit. I don't know if that answers your question or.
But it goes to collections basically, and then collections agency can report it.
Yeah, that's how we normally see these things pop up if they do.
Can they report? Well, I guess that will probably be for one of our financial classes, but I was thinking about if in the instance when you've got a debt collection because they no longer report the eviction on the credit report, if you were evicted, you don't owe any money for the rent. Is there any way that it still shows up on your credit report as an eviction?
I want to be very specific because there are kind of two different types of reporting that we see, and they sometimes
Mm-hmm.
get conflated. The first is credit reporting, which is pretty strictly regulated relative to the other type of reporting. Um, Credit reporting really deals with just the amount owed to different parties. It's meant to sort of say whether or not you're a good bet to lend money to.
Mm-hmm.
So, like if you don't owe anything to the landlord, let's say that this is a conduct-based eviction on, there's no issue of money. Like that shouldn't be reported to a credit reporting agency. Now, the other type of reporting is tenant screening reporting, and that's a lot less strictly regulated than other credit reporting. And like not only would a judgment be reported on that, even whether there's rent owed or not, even the filing an eviction is oftentimes reported on those reports.
Mm-hmm.
So I do think that they also report amounts that are claimed to be owed as well. So and again, that report is different than credit reporting in the sense that it's something put together that tells a landlord information about whether they want to rent to somebody or not. So
I just kind of wanted to touch on that because I've seen also some people will say, oh, well, I checked my credit report and the eviction's not on there. Okay, well, the eviction's not on the credit report, but that doesn't mean that the new person that you're trying to rent from doesn't see it because they got that rental, whatever that rental
yeah,
report is, whatever it is that they check, they still see that you've been evicted, even though that there's nothing that's on your credit report per se. So I just
yeah.
wanted to make sure that we got that part out there.
I mean, to add to that, and we do sometimes see this where someone will, apply someplace and be denied on the basis of a past eviction, usually in regards to something that has gone up on appeal and they've gotten a different outcome on appeal than a I'm sorry, the JP court. Um, you have the right to ask for a copy of your tenant screening report to review it for accuracy. And if it comes back and it says that there's a judgment against you when you had a case dismissed at county court, that could be actionable. That's the sort of thing where if you see that, you should reach out to an attorney to see what your rights might be. Or a copy of your tenant screen.
Oops, sorry. Can you all hear me? Or
Mhm.
am I stuck? Oh, okay. Um, trying to look at YouTube here to see if I had any questions on that one. And I don't see any there. Okay, I think that's pretty much it.
Okay.
Um, yeah, I don't see any there either. Okay, but yeah, I think that's pretty much it. For those folks, as bored as you may be, advice would be to make sure that you guys read your actual lease because everything always kind of depends on what's in the lease. Every time I go to ask Kim a question, it's always depends. It depends. It depends. So you need to know what's inside your lease. And I know most people don't read them. They just kind of know that they have to initial on the bottom of the pages and sign the last page and that's it. And they don't really read all the details or they get it electronically and they don't really see what it is that they're reading. But it's important that you read your lease. Um, Question about reading the lease, are you required or are they required to give you a copy of all those pages and things that are in the lease for you to review before you sign it? Because I know most times when people come in and they like go to pick up their keys and things like that, here, sign these documents and we'll send you an electronic copy or whatever, but it's always after you already signed it.
Yeah, I mean, what I would do in those instances is just they can't make you sign something without reviewing it. But there's not like a set time where like they have to give you it a week ahead of time to review it. Um, what I would do if I was signing something like that and was take out my keys and They wanted me to sign a bunch of stuff. Sit down, go through it on the spot. Review it, before you sign on to anything. Because once you've signed it, like whether you've reviewed it or not, it's going to end up becoming binding. Because the court's not going to look into whether or not you spent enough time looking at it in order to find it binding.
Right.
So just, you know, don't sign a document blind. If they're trying to get you to sign something, you can say, hang on, I'm going to sit down, I'm going to review this before I sign it. That's fair. If they're trying to rush you, without having a chance to review it, that's kind of a red flag. Or at least I
Mm-hmm.
would consider that a red flag. But yeah, no, I don't think there's a statutory requirement of any sort that says that you need a particular amount of time, but absolutely, sit down, review it. And if they don't let you review it before telling you to sign it and say, just sign here, don't sign it.
Uh, I want to ask this question too. If, say, for instance, you make an arrangement, you uh, sign a lease, you're supposed to move in on the first of the month or whatever it is, and today is the 15th. Something happens, falls through, you don't actually move in. Are you still then stuck at that with that agreement, even though you just signed it, but you never moved in?
Um, I believe that you are because you have a right to possess the property. I actually think there are some leases that even assess certain damages against the tenant if there's some form of delay in move-in. Um, I'd say it really depends on the lease itself, but I mean, generally speaking, if you have a right to possess the property and right to possess the unit, and there's an agreement there, you're going to be bound by those terms.
Okay. All right. I was wondering because that had come up before too. Our organization has an apartment complex, and I was questioning one of the property managers about that, and she kind of went around about, and I'm like, okay, well, let me just ask them because I
Yeah,
needed to kind of get an idea, but
yeah.
okay.
I mean, keep in mind, even if you haven't moved in, if you've signed an agreement to possess the unit, and the unit is yours, the landlord is not free to turn around and rent that to somebody else. They're not free to make money off of that some other way. Like your agreement means that, you know, there's some benefit being provided to you at the expense of the landlord. And so, unless the landlord is the reason for delay in move-in, you know, like there's not going to be a whole lot of argument that, there's not some form of benefit you're getting from that at the expense of the landlord. So,
Okay, so in that same instance, then if they're not allowed to re-rent it or anything like that, how can then they come after you if you were to get evicted or move out or whatever before the end of your lease, and then they try to charge you the fee for the remaining months of your lease, but then they're going to turn
so
around and then rent it out anyway. So now they're getting the money from
Well,
me and then
well,
getting the money.
so so that's the thing about, and I think this is why we don't normally see those acceleration clauses enforced, is that the landlord has what we call an obligation to mitigate their damages if there's an acceleration clause. So mitigation of damages is a contract theory which says that if one party is going to court to ask for damages under a contract from somebody else, and they've not taken steps to sort of minimize those damages, then the court can look at that and say you're not entitled to a certain amount because you could have gotten in some other way.
So you
But the
could have
idea is,
rented this place out if you wanted to put it back on the market, but you didn't. So you
yeah,
can't then just come after them because you didn't choose to
yeah,
rent it out. Okay.
exactly. So you can't like
Gotcha.
sit on a unit that you could have rented out,
Gotcha.
and say that you're going to pay. At least that's what the theory would be if that was fully litigated. And again, I
Okay.
don't think I've ever seen an instance in which that has come before the court, but it would play out something like that. Is that one party would say the lease allows us to accelerate these and we want payment for the full amount. And then the defense would be you failed to mitigate, you could have rented this out to a different tenant, you didn't.
Gotcha. Okay. I believe those are all the questions that I had. The available online resources that Mr. Daly has listed there on the screen. I will be sending those out along with a copy of this recording, along with some other available resources that you all may potentially reach out to in case you have some other questions about your rights, different websites that you can go and look up information as it relates to tenant rights will be included as well. Also, a link to our YouTube channel for you all to go back and watch some of the other presentations that you may find of interest as well. So we want to thank you all for joining us this afternoon. Tomorrow we've got it may not be too relative to you guys, but tomorrow we have maintaining and adding value to your home for those folks that are homeowners and they're looking for some home maintenance tips and wanting to know what actually adds value to your property. We've got that coming up tomorrow. And next week we've got our coffee and conversation with the City of Houston Department of Neighborhoods and all of our AMOS partners. We will be out at the A-Leaf neighborhood centers in person from 10 to 2 on Tuesday. So if you guys have any questions, you want to apply for different services, you can feel free to come out there and ask all of us any questions that you all may have. So we will be available there. As well as our first time homebuyer education class. We have, so if there are any renters that are interested in home ownership, our organization does offer first time homebuyer education classes once a month. And that one is scheduled for next Saturday from 9 to 3 p.m. If you just go to our website at nrcdc.org, you will see the calendar and all of the other events that we've got scheduled as part of the month of service, as well as some other workshops that are available as well on that site. If there are not any workshops or information that you guys may be interested in that we don't currently offer, please feel free to reach out to me and let me know. There's a link that's going to pop up on your screen for a survey. If you guys could just take a couple of quick minutes to fill out the survey and just kind of give us your feedback and let us know, you know, if you did receive the information that you came here to get, if you need additional information, if you have more questions, if there's some other pertinent thing that's going on in your neighborhood, in your community that you want more information about, then reach out to us and let us know. Because otherwise, that's the only way we know what we need to continue to schedule or not to schedule and things like that. So please let us know. We would love to have your feedback. But in the meantime, if there are other questions that you may have next month, you want to hear an update on what's going on, as he mentions, what's going on with the legislature, please feel free to come back next month. We are here the third Tuesday of each, 1, 2, 3, I had to think about that, the third Tuesday of each month with a live presentation to give you guys the most up-to-date, the most accurate information as it relates to your rights as tenants and the eviction process. So, Mr. Benjamin, thank you very much for joining us this afternoon. I know you kind of came rushing in to save the day this afternoon and to fill in for us, and we definitely wholeheartedly appreciate that and appreciate your time because you could be doing some other things right now. And know that, like Benjamin, we have volunteers that actually come in to give these presentations. You know, they do take time out of their schedule to make sure that they actually get back and provide information for the community that you all can receive. So we want to thank you all for that as well. You all have a wonderful remainder of your afternoon. You take care of yourselves, you stay safe, and we will see you all next time.